of issues developing in Parliament. It's time now to take you back just to give a sense of what's happening right after minority made that pronouncement that they will not be touching in matters relating to the approval of the Chief Justice nominee until that firm determination is made on the latest ruling by the Supreme Court asking Parliament to expunge the name of James Gyakye Quayson as Member of Parliament for Asin North. We can take you to the House now. My colleague James Kwesi is, of course, on standby for us. He's been monitoring the exercise throughout the day and now comes through with all that's been happening. A number of concerns have been raised about issues relating to dual citizenship, issues bothering on the birth certificate and the ruling of the Supreme Court on it, the Chief Justice nominee indicating her position on that, and some matters relating to death penalty being on our books. Quite a lot has happened, but the long and short of it is that the minority insists that they will not be making any determination until the ruling, the reasoned judgment on the decision asking that Parliament expunge the name of James Gyakye Quayson be brought before the Appointments Committee. Let's take you now to Parliament. My colleague James Aveji is there for us. And of course, we can now get you some live pictures from the House. Just a few moments after that vetting took place, finding the replacement for what is likely to be the successor of Justice Enin Yeboah. We've seen him also appearing before the committee today, ostensibly to support the incoming Lady Justice, who is now subject to parliamentary approval. We're waiting to see what the minority will be saying, probably at a press briefing that's likely to happen in the House. James Aveji is joining us now with more. James, if you can hear me, just give us a sense of what the reaction has been, especially from the minority side, which is giving indications that it will not be involving itself in all of these processes unless the judgment is provided.
Yes, blessed. So the indication was initially given by the minority leader, Honorable Kesela Tofosin, in his opening remarks, where he made a point that even though they are coming to start the process will not be concluded on the side of the minority unless the full ruling or the reasons behind the Supreme Court's decision to actually write to Parliament to expunge the names and all the particulars of Honorable Gyakye Quayson, disqualifying or taking him out of Parliament is made known to them, or the full ruling is given out. So that is where the first indication came from. Then later, Honorable Mama Yariga raised the issue again when he questioned the Chief Justice. Now, the response from the Chief Justice basically has been that she was of the view that this whole vetting would have looked at her time as a lawyer and as a judge, taking into consideration generally the entirety of her work, but not zoomed down to a particular issue. And so that was the initial view. Then the issue came up again from other members of the minority in their questions. Now, the second explanation she gave was that she would want to respond to it because the matter has now become of public interest. Now, she explains, or she gave the education that, in fact, the Supreme Court actually sits on a case only when at least 5 of its members are present. And so the decision on a matter is a decision of the Supreme Court. For instance, if the judges sit on a case and they want to come to a ruling, every individual judge on that case would have to submit their written judgment on the case, which will be compiled into a final decision known as the Supreme Court decision on the matter. And so it will not be really accurate to want to know her position on the matter, and would want to determine her fate by her position on that matter. So generally, that has been the exchange on that matter, and the education provided by the Chief Justice nominee, Justice Torkornoo, on the matter so far.
What's likely to happen, because the minority side indicating that they will not be taking any further steps unless that reasoned ruling is provided. Are we likely to see a press briefing or an explanation from the minority side shortly?
We have been trying to get some words from the minority on that, but both the minority and the majority indicates that they would have to conclude the final business on the matter. As I speak to you, the committee is reconverging in order to take a decision on the matter. We know that when vetting is concluded, the committee would have to meet again on the matter to take some decision. And so we are waiting. The members of the minority actually have gone into that meeting of the appointment committee. And so we are yet to determine whether they would make themselves available to take a final decision on the matter, or they will recuse themselves, and what that would mean for the fate of Chief Justice nominee Justice Torkornoo. And so that indication has not been given yet. We'll pick that when they finally come out of that behind closed doors meeting between the two parties. Blessed.
About the majority side, because they do not accept what it is that the minority is doing now. The accusation is that they are heckling the process. We saw that announcement by the chairperson of the appointments committee, the first deputy speaker, I should say, indicating his displeasure about the politicization of the entire process. Bring us up to speed with why he's saying what he is saying.
Yes, in fact, part of Justice Torkornoo's explanation was the fact that if you look at the entire court system, the Supreme Court reserves the mandate to protect the justice system. And so it cannot allow members of the public, being it those from the political realm or ordinary citizens, to denigrate the image of the Supreme Court beyond what the rules provide, going into the matter of contempt. And so the first deputy speaker and the chairman of the committee agrees with her position on that. That is where in his concluding remarks, he advised members of the public, especially politicians, and most especially those of them who are lawyers, to watch their remarks on rulings taken by the Supreme Court. He advises that they need to be very measured in their opinion on the rulings of the Supreme Court, especially they lawyers, because they would need to set the right precedent for the ordinary citizens or the ordinary Ghanaian to also follow. And so he agrees with the view of the Chief Justice nominee that all of us owe the duty to protect the Supreme Court, to allow the Supreme Court also to protect the justice system in whatever way we can. And so if our opinions or the opinions of politicians as well as judges would in any way denigrate their image, that cannot be encouraged.
James Kwesi, my colleague, giving us the latest from Parliament. Grateful for your time. I want to bring in now someone who understands what this legal implications will be. Justice Abdullahi, he's a law lecturer, joining us via Zoom now. Thank you, sir, for your time. Quite a lengthy exercise in terms of vetting of who's likely to be the successor of Chief Justice Enine Yeboah. He himself was in Parliament today, appearing before the Appointments Committee. Let me take your thoughts, first of all, on the nomination and the entire decision by the President to have another female, and for that matter, Justice Torkornoo, Mrs., to become the next Chief Justice. Your thoughts on this? And kindly unmute for me so I can hear the point you're making.
I really can hear me now.
Yes, loud and clear, sir.
I think, for me, the nomination of Justice Torkornoo is not just based on the gender issue. She's not just a woman. She's not just the lady, and so on the basis of which she was appointed. I think we probably would have witnessed today her dexterity and appreciation of the law and communication skills, that she's well endowed with all that it takes to be a Chief Justice. I remember before her nomination, we had an interview on this subject matter, and I mentioned that she's one of her kind within the judicial system, and she's a solid judge, and so I think one of the MPs even mentioned that whilst a student, he used to go to they used to go to her courts to learn company law and practice, among other things, because no one would take it away from her that Justice Torkornoo is such a brilliant, fine judge. And so her nomination, I wouldn't want to see only from the light of her gender, or the wealth of experience, the knowledge, and the display of the knowledge and application of it. She stands out. And so for me, it's not out of place at all that she gets the nomination to be the Chief Justice.
Unfortunately for her, she's been caught up in this whole political web of why we're seeing the minority side take up the case of James Gyakye Quayson. It's as though they're settling scores in Parliament. The demand they're making, asking the Chief Justice to make available the reasoned ruling for which the Apex Court is asking Parliament to expunge the name of James Gyakye Quayson from the list of MPs. How difficult is that, or otherwise, for the Chief Justice? Nominee, I should say.
Indeed, it is difficult because she's a Chief Justice who has both administrative responsibility and judicial authority to administer. And if I remember, the Supreme Court, in delivering their decision, mentioned that the ruling was to be ready at a specified time. I think that now asking the Chief Justice to produce that before she can be endorsed or otherwise takes a lot from her. Because first of all, because she's not the Chief Justice at this moment. Second, the decision to deliver the ruling has already been made and the timelines have already been spelled out. She does not have the authority to compel her colleagues to produce that reasoned judgment. She can only appeal to them, but under this particular circumstance, it becomes a bit awkward that she does that kind of work. I think that the minority could have done this better rather than holding her ransom to this. This is because the minority has a lot of lawyers, and they know that once the Supreme Court has said this, on the specified day, if the judgment is not out, then you have a reason to complain and complain to either the Chief Justice or whoever will be. I think now Justice Doche is acting to complain to him that we are awaiting this particular decision. So without this decision, we cannot make progress. And indeed, all of us know that sometimes if the decision comes and it comes late, it becomes impossible for you to take the next step. For instance, I'm assuming that the minority would want to have the right of review, and perhaps the decision may come at a time that their right of review may might have escaped them. I'm thinking that is why they have taken this hard position. But from what I said, I think that being a minority, they could probably have a better way of going about this. It is not an ordinary stabilizing on the fence, insisting on something of this nature being done. Because probably you don't have any options available to you.
But while we carry out this analysis, we equally have to be fair to the minority side of the House. We need to point out that all they are asking for is that they are awaiting the ruling of the courts. Then they can, of course, take on the nominee on that. It's within their rights, clearly, isn't it?
I'm not even disputing that at all. What I'm saying is that if it is just about the ruling, obtaining the ruling, about the judgment, there are other means of getting it. Timelines have already been provided. If the timelines have not been breached, holding a nominee to that timeline when he does not have authority to change that timeline is a bit difficult. That is the question that I'm pushing across. But of course, that is not to say that, like I said earlier, a minority cannot approach a Chief Justice or any other person, either the acting Chief Justice or the nominee Chief Justice, to fast track the release of the judgment. They can do that behind the scenes. These things can always be done, particularly for people with authority. They can always get these things done. I can understand the fact that the minority also feels that, of course, the majority or the government, the executive, has a role to play in when the suspicion of the minority is obvious in the face of this. That by the time the decision will be out, even an attempt to have a review may not be available to them.
Here's the case. Justice Torkornoo seriously, and I believe so, wants to become the next Chief Justice. We know that constitutionally we cannot coerce the justices of the apex court to decide or to act in any manner. But James Doche, Justice, was also in court today. Justice Eninyebwa, who's outgoing, was in court today. If there's any sort of
today.
yes, so if there's any sort of influence to bring to bear now, what would you advise that the members of the bench do? I mean, respectfully, because we all want to make progress at this moment.
Absolutely, I would have no doubt that they all heard and saw the position of the minority, and so pressure will be put on bear. Put bear to for those writing the authoritative decisions. If all of them are writing, I'm sure all of them will now see the seriousness and the gravity of the situation, and possibly go beyond their normal scheme of doing things to ensure that the decision is released on time, possibly before even the stated time, so that these hurdles can be
Another issue, very contentious one that has come up, has got to do with matters relating to dual citizenship, and it's still around the issues surrounding James Jachi Kwesi. We know that at the parliamentary level, efforts are being made to revise our laws, but it's playing out that, as far as our laws are concerned, matters of dual citizenship ought to be clarified. Do you feel that the law is clear enough on what it says about MPs, about our lawmakers, and what their citizenship status should be whilst they are entering the House?
I do not think there is a problem with the law. And I do not, in fact, nobody has actually complained with the clarity of the law. The law has been clear. I think the problem is with the banning of dual nationals from holding specified positions. And, of course, determining at what point in time the person could be said to be a dual national or not is a matter of fact and law. If you are dealing with a particular country that allows you to denounce your citizenship the moment you file your decision to denounce it, it takes effect right from that moment. But if you're dealing with a country that goes beyond that, goes beyond filing the denunciation to sometimes having all kinds of meetings, conferences, and interviews before it is accepted or allowed, then it takes a different turn. Now, the problem with our people, our MPs, have always been with this, whether the moment of the filing is the time that they are alleged to have, you are alleged to have denounced your citizenship of the other country, or it is the moment of receiving the certification. So this has been the challenge, really. So it is not really about the clarity of the law. The law is very clear. What I have heard JM, for instance, the ex-president, to be saying, for instance, is that he would want to have those issues involving the dual nationals not occupying specified offices, because dual nationals are not allowed to occupy specified offices. He would want to take those things out, because for him, we are losing a huge amount of resources simply on the basis of this law. And so he would rather want these persons to come into this country to be able to occupy positions that they could influence, to be able to help with our development. And so that's why he's pushing for that. The bill in Parliament, if you've seen the bill in Parliament, which was filed, I think in 2018 by the Assistant President, on the basis of the decision of Asari and Attorney General on this same issue of dual nationals and the position they occupy, it's clear from that bill and the memorandum attached to it that there is some form of dissatisfaction, even with current government, with the existing law. And so that appeared to be a conclusive decision on the part of both political parties that we need to revise the law, not on the basis of the clarity, but on the basis of bringing up all our citizens from wherever they are, regardless of the status of their nationalities, to contribute to our development, and then also decriminalize this whole aspect of it. Because we've lost others on the basis of this state, and we've lost them. If you remember, Draman Sakandi is gone after the imprisonment, but a few others also going through the same tortured life because of this same law. And so if you have to revise it or amend it, if we are amending it because we believe that these people have something good to offer all of us, and their continuous incarceration will not serve any useful purposes for our national development and national efforts.
The dual citizenship is equally connected to this because for the minority side, and apologies for being fixated on the minority, they seem to be having quite a number of issues, including that ruling that I'm about pointing to, the decision by the Apex Court indicating that the birth certificate is a proof of registry and not necessarily citizenship. That's also causing some stir.
Indeed, it is. Ordinarily, I would disagree with such a decision. I was shocked when that decision came out. For now, that's what the decision is. We may have to settle with that until the Supreme Court changes its mind. But otherwise, I thought that it went beyond just the bearing the record that it bears. I thought it was also a form of identification and indeed a form of connection to a particular jurisdiction. I think this should be clear on the face of it, but if the Supreme Court says otherwise, for now we may probably have to settle with that until we have a new decision from the Supreme Court.
And so going forward, for now, we're not certain if the minority side will indeed participate in the exercise, but we saw the first Deputy Speaker, Joseph Osei Wosu, there expressing his displeasure about how the vetting process and approval processes leading to the confirmation of, successive Chief Justices becomes matter subject to partisanship. It's come up really strongly, and this time around it appears that we can't avoid that as of this moment. But what's your suggestion in terms of how we can vet all of this and go by it, avoid it in the first place?
I think it all has to do with the issue of the nomination, the appointment authority. The appointing authority has always been the executive. I had in the past made recommendations that if the Judicial Service would have a bigger stake in the nomination and appointment, it will probably relieve all of us of the politicization of who becomes our Chief Justice, because we are already polarized. And this current parliament is even worse because of the sharp division. And so you're likely to find this happening going forward until there's a massive reform in the entire nomination and an appointment of the Chief Justice. And I strongly will continuously recommend that the Judicial Service itself be given that authority to have a Chief Justice rather than the executive doing this job on behalf of all of us.
For me, what did not feature as much as I would have expected it is the issue about legal education reforms. It's still a subject matter on the front burner, you agree?
I completely. We still have the new law school at the University of Professional Studies still waiting for construction. From the moment the commission took place, not even a block has been laid. Much as I disagree with the construction of that block, but it would have, I believe that it would have helped ease the numbers. I still recommend that we have a general legal counsel overseeing the activities of professional law course, not necessarily by having break and blocks sitting there for students to be admitted. I would still recommend the structure that YP presently operates with for students who want to do research, for instance, so that everybody can have classes from wherever you want to have his classes. The General Legal Council should simply be focusing on giving out the areas that they believe, the curriculum, and the areas they believe are important for the purposes of their examination. If you go sit the exam and you pass, wherever you sit the exam, you can sit the exam in Yo or from the farthest corners of this country, without necessarily having to go to any particular school. If you want to have classes, you have your private classes with whoever you want to have your private classes with. That way, there will be no issues with admission requirements and the numbers that are admitted. When you have an exam of this nature and the students pass, you can then determine further criteria in regulating the core and the people who get licensed. For me, the licensing regime should be the focus of the General Legal Council, rather than continuously fighting for resources to build blocks and build classrooms and all other matters. However, once it has taken that decision to build, I expect that it does as it has promised to do. And in which case, I would strongly recommend that each region of this country has to have a school block. Because we cannot have the concentration of everybody in Accra and Kumasi when we have 16 other regions that are also entitled to have these same edifices within their respective regions for students coming from those regions to be, not to think of paying rent in Accra and commuting from wherever they would probably have the rent, accommodation from in Accra to wherever they have to go to school. They can have this thing within their regions. It is also part of development. It's also part of means of reaching out to all and sundry within this country so that everybody can have access to legal education at the minimum barest cost.
Let's talk about the political appointments itself. That controversial research by Professor Raymond Atuguba on the appointments and the likely influence on decisions of the courts itself. Is that likely to come to the fore now that, of course, President Akufo-Addo is having another shot at appointing who the next Chief Justice will be? He's had the opportunity twice, quite a rare situation.
Well, I think for matters that will come up during the vetting would largely be dependent, but would be, I'm sure it will be overshadowed by the impressions that the minority has of the Supreme Court. If you remember, the election petition is not far from us. The minority had a lot of misgivings, and these misgivings are likely to be exposed during these vettings. And so we shouldn't be surprised to see those misgivings coming up at the vetting.
And the expectations, for those of you who are, from the position of the bar, what reforms would you equally like to see? We saw Chief Justice Eni Yeboah, whilst he was moving out, bring up this whole new mini call, if you want to put it across. It's causing a lot of controversy even amongst your profession, and a lot of people looking up to the new Chief Justice to state a position on that. Do you see that changing anytime soon? And what's your own thoughts on that?
I heard the General Legal Council denying the controversial about lawyers having to write an exam for their licenses. So once it has been denied, I think we let that go. But as I indicated, Justice Torkornoo brings a lot of wealth to the office. I mentioned that the biggest of what you bring, what she brings, is the issue of what's it called, IT, electronic administration of justice. And I think I heard that she actually re-emphasized on that position this morning when she was being vetted. Because she has been in charge of this portfolio, even was as an ordinary member of the Supreme Court. And I know she's passionate about it, and I know it will go a long way to ease the overburdening cases in our courts But of course, the expansion drive that was commented by Georgina Wood, which was continued by Justice Enini Yeboah, I would have no doubt that Justice Torkornoo would continue with the expansion drive by building more of the more of the high courts, the court of the circuit court and the district courts across the country. I think justice at the doorsteps of Ghanaians is the best way of reducing not only the incidence of cases, but also reducing the timelines. I mean, we can't spend 5 years in court resolving an issue as little as who owns a particular piece of land. Why would you spend 5 years? It's mind-boggling. I mean, we are in 21st century that some of these things could be done within a day or two. But you're not spending 5 years, sometimes 10 years, and you are still in court over the same subject matter. I think the expansion drive and the IT bit of it would reduce this huge backlog of cases. And I have no doubt that Justice Torkornoo is going to pursue these vigorously. I do pray that she does it even more than her colleagues have done, because as we grow, these things begin to be more pronounced than we ever expected it to be. So I expect a huge expansion in the drive for more courts, more judges, and then indeed more IT-enabled judicial delivery of justice.
Key issue, corruption perception. She's been speaking about that. She says there's a whole cabal within the judicial service, or the judicial system, if I should be clear on that, is working assiduously, and you find these unscrupulous persons siphoning funds from persons who are seeking justice. She says out of 10, you find 9 of the persons taking bribes on behalf of the justices having those funds or those monies being kept by themselves. But that's also an admission that there is a challenge when it comes to bribery and corruption.
There is a challenge. Sometimes it's difficult to know when you win a case whether you won it genuinely, particularly if you are an innocent lawyer. If you're an innocent lawyer, a naive one, you go to court having read all your authorities, your books, done proper analysis, and you win a matter without ever knowing that even your client went behind you to see somebody who knows someone who knows the judge, and somehow the decision goes in your favor and goes in your favor. It's difficult sometimes to say. Of course, there are times where lawyers are also involved. It is very difficult to be able to, at this moment, fashion out a proper solution to this problem. But I think the best we can do is to ensure that when it comes up, we deal with it decisively.
Yes, but there'll be a lot of expectation because we've seen, for instance, the Anas case, we've seen other interventions, and all of these things raises key questions about cleaning the image of the courts.
Indeed, so you see, there is no single solution to the problem of corruption in the judiciary. There is no single solution. The biggest solution for me is what I keep saying: the expansion drive, the IT drive. These are, because once the timelines are reduced, you can always go on appeal, and the person cannot bribe his way through all the way to the Supreme Court. It's almost impossible to do that. And so, if you have a huge numbers of the courts, huge numbers of judges, chances are that you meet a good one. Of course, there are also chances that you meet a bad judge who may be susceptible to corruption. But until somebody identifies it, you cannot be going around setting up people in the name of fighting corruption. I do not think that is the most appropriate means of fighting corruption, particularly within the judicial service. I think there should be a better means. Maybe there should be a better reporting room. There should be a room for anonymous reporting. There should be feedbacks from such reporting when they happen. There should be a lot of opportunities for people who feel aggrieved to be able to air out some of these pent up feelings. But in all, I think that each region, once again, possibly each district, should have a reception to receive complaints from from the members of the public who patronize the judiciary. So that you don't need to, for instance, at this moment, everybody who, if you have a complaint, particularly against a lawyer, you have to come all the way to Accra, complaint to the the General Legal Counsel. If you have a complaint against a judge, I don't even know where you would go if you don't come to Accra, because there will be no other place. Even though there are offices across the country, but I think that complaint centers should be available in every area that we have a court, so that people, and it should be manned by independent persons who are willing and ready to fight corruption. They should receive this information, send them across, and if these things are implemented to the fullest, I think it will reduce the incidence tremendously.
Justice Abdullahi, grateful for your time here on The Pulse. And please stay with us. I will give you some updates of what's happening in Parliament, plus get you some updates on the stories coming through here at Joy News. This is The Pulse. We'll be right back. Please stay.